Good afternoon, everyone. I, Ashraf Azmi, Assistant Professor, Faculty of Law, Integral University. It is my pleasure to welcome you all to the Module 3 of the Faculty Development Program, focusing on the critical theme of integrating IPR principle into teaching, research, and professional activities. Today's technical session, Global Comparison of IP Laws, Implication on Research, promises to be an insightful journey into how intellectual property laws differ across the jurisdiction and what these variations means for researcher and academicians globally. In today's interconnected world, understanding the global landscape of intellectual property is vital not only for safeguarding our innovation but also for fostering across border research collaboration. As we delve into the international approaches to IPR, we will explore how the global perspective on IP laws influence research methodology, collaboration, and the protection of our intellectual assets. We are privileged to have Asma Farooq, a distinguished professor of marketing and business law at the Integral University, with over 2 decades of experience in teaching and research. Dr. Farooq's extensive work in the field, along with her vast contribution as a researcher, mentor, and leader, will undoubtedly enrich today's discussion. Her insights into global and local dynamics of IP laws will be instrumental in understanding how we can apply these principles effectively in our academic and professional pursuits. Let us take let us all take this opportunity to engage, learn, and enhance our understanding of how the diverse legal frameworks around the world impact our research, innovation, and academic work. Thank you, ma'am, and I look forward to a fruitful session. Welcome, ma'am. Over to you.
Thank you very much, Mr. Ashraf, for the introduction. And first of all, I would like to extend my thanks to Dr. Seema Siddiqui, Head of the Department of Law, the Dean of the Faculty, Dr. Naseem Jafri, for providing me this opportunity to speak on a very pertinent topic, that is global comparison of IP laws and its implication on research. Since all of us are related to the academic fraternity, so it becomes very necessary for all of us as researchers, as supervisors, and as teachers to understand the implications and significance of IPR in the current scenario. I have divided my entire session into different categories, starting from the types of intellectual property rights to its relation to the economic growth, how it is connected to morality, what are the international frameworks, and how do we globally compare IP laws, the challenges which are ahead of intellectual property rights, and why it is significant for us to understand this as a researcher. And there are different IPR laws in India. So IPR is a broad term for India, and we have different acts which are covered in the IPR. So I'll try my level best to justify the topic and have a brief overview of global comparison of IP laws. Though it is a very tough task, because if we look around into different nations, especially which are advanced countries, which are developed countries, they have better and a robust system of intellectual property rights in comparison to countries which are not so developed, and they do not have a strong framework of international guidelines related to this IP laws. But I'll try to cover the major of them, or the ones which are known for their best guidelines in intellectual property rights. So let me begin. This is just a slide which is indicating the types of work which are covered under intellectual property rights. It may be in the form of a literary work, in the form of a film or a documentary which is created. It may be in the form of music, in the form of architectural designs which are done by engineers and architects when they are designing a building. It may exist in the form of trademarks, in the form of punchline, in the form of shapes and designs of bottles or packaging. So, to begin with, intellectual property right, it is a category of property. Since I belong to the stream of management, so I'll try to give a marketing aspect to this topic. So this IPR laws they became more important recently, though they have been existing from the very long time, and they are not new into formulation or drafting. But because of large number of brand players in the market and close competition between different type of products and services which are provided by marketers, it became necessary to have a legal touch to all the goods and services and commodities which are existing in the market. So IPR came into picture and it became more prevalent and common among researchers and academicians. Earlier, the law was always there in the Indian setup also, but people were not aware about it. And the reason perhaps was that people didn't realize the significance of intellectual property rights. But with the passage of time, it became more prevalent, more significant, and necessary. And gradually, it became unavoidable. As we are moving advance in technology, in science, in engineering, every day we are coming up with new ideas, new innovations and concepts. And everybody wants those ideas to be protected by their own name. That is how the intellectual property rights became very prominent in India as well as in other countries and at global platforms. Usually, the intellectual property right which we come to know in day to day working is related to patents, it is related to copyrights, trademarks, trade secrets, also designs in circuits, in pharmacy, in medicine, and also in the form of geographical indicators. So, every day with the passage of time, new acts are coming up which are required for protection of rights related to the innovators and authors. The supporters they argue that intellectual property law it allows people to protect their original ideas and it also prevents them from being copied, which is a very challenging task. People do not want their ideas to be copied, and somehow when it gets converted into a form of a product or a prototype or a service or a model, then it also gives an economic contribution to the society. And that is why it became significant that people wanted to protect their ideas and innovations in whatever form they had materialized. Advocates or lawyers also say that economic incentives and legal protections they help in new innovation. If people come to know that their innovation, their ideas are being protected, obviously they will go more for intellectual property rights and will try to get their ideas protected under IPR. Coming to the types of intellectual property rights, we would be very quickly discussing about the major ones or the most common ones. So, as already discussed, these are trademarks, plant variety rights have also came up, trade dresses are also covered under IPR, geographical indications are also a part of IPR laws, and trade secrets are some of the most common ones. If we talk about United States, which is considered one of the most advanced nations in terms of technology, in terms of engineering, and it is also advanced in terms of intellectual property laws also. So they also have an additional right for circuit design rights, and they provide supplementary protection certificate for pharmaceutical products because these products they have a certain expiry date. And the same method or process is prevalent in European laws also. The next is, which is the most common one and we usually know about, is a patent, which is a form of a right which is granted by the government to an inventor or any successor to the title. So this provides the right to exclude others from making, using, selling, offering to sell, and importing an invention for a limited period of time in exchange for the public disclosure of the invention. So this invention is usually a solution to a specific technological problem which might exist in the form of a product It might exist in the form of a process, or generally it has to fulfill three main requirements. And those requirements are it should be something which is new, which is very clear to the public at large, and in the long run or in future, it should have industrial application. So it should be new and it should have some industrial purpose. It might be converted into a product or a prototype or a service which or a formula which is used by industries in the long run. So to enrich the body of knowledge and to stimulate invention, it is obligation for patent owners to disclose valuable information about their inventions to the public. So how will the public come to know? And once the public comes to know, the idea does not remain your own idea, and that is why IPR laws are required in India as well as in other countries. The next important form of IPR or a protection which is available under these laws is copyright, which may apply to a wide range of creative ideas. It can be in the form of intellectual work or it can be in the form of artistic forms. So, copyright does not cover ideas and information themselves, the only form or the manner in which they are expressed. It can be in the form of a visual design, or it can be in the form of a shape of a bottle, the formula, the composition of pattern, colors, combination of pattern, or it may be a three-dimensional form which is having some aesthetic value. So an industrial design can be a two or a three-dimensional pattern which is used to produce a product, industrial commodity, or a handicraft. So generally speaking, it is what makes a product look appealing. So this is known as industrial design. And copyright is related to the published work, which can be a written material, it can be a design, it can be a diagram, it can be a formula. The next, which is most popular, is a trademark. Trademark we can connect with. We every day we buy a lot of products which are uh, consumed, like FMCG products, that is fast moving consumer goods and consumer durables. Even if we are buying a soap or we are buying a Coke or a Pepsi, all these products they have a certain logo or the name of a brand. Now, the name of the brand or the logo which they are using or the design which they have selected for their particular product to be promoted is the trademark of that company. For example, the Coke has a logo which is the trademark of logo, and Coke also has a formula by which the Coke drink is being manufactured. So that drink is coming in the form of a patent. The formula is the patent, but the design or the logo which they are using for the promotion or the marketing of their product is the trademark. The same applies to services and other traders also. Then we have trade dresses, which refers to the characteristics of the visual and aesthetic appearance of a product. So sometimes products which have a specific design in the packaging form, they go for trade dress also. And the last is trade secret, which I already said, which may be a formula for a particular drink or a product. Now, intellectual property rights has gradually become very significant these days. Somehow it is connected to the economic growth of any country. Now, the organization which is keeping a check on all international platforms of laws is WIPO, which is keeping an eye on all international agreements which underline the protection of intellectual property rights as it is contributing to the economic growth. Now, there are two important reasons. The first is that the moral and the economic rights of creators are connected to their creation. So, the people they have economic right, they have a right to earn money through their contributions, and they also have a moral or a legal right that their ideas they remain protected with them, and no one else is using their ideas. And right of the public in access to these creations. But the public should also know about those ideas. The second is to promote a deliberate act of government policy, creativity and dissemination and application of its results to encourage fair trading, which should contribute to economic and social development. So this a simple idea, a concept which is coming in the form of IPR. is not only contributing to economic development of the society, it is also contributing to the social development of the society. The next part is how morality is connected to intellectual property rights. So, if you go to the Universal Declaration of Human Rights, according to Article 27, everyone has a right to protection of the moral and the material interests which are arising out of scientific work, or they are arising out of literary work, or it is the artistic protection of which they are founders or innovators. So the relationship between intellectual property and human rights is also existing in the longer run. And that is why intellectual property rights, when they came into picture on international forum, it was realized that somehow they also enter the boundary of human rights. And if you look into European nations or in Western countries, people are more cautious of their human rights. So a interface was also found between intellectual property rights and human rights. If we talk about international framework, whenever there is a conflict between human rights and IPR laws, it is always the human rights which will prevail. This is a decision which was taken by WIPO that a conflict between the two which should supersede or which should have a upper hand. One of the most important aspects of global IP governance is the agreement on trade related aspect of intellectual property rights. So this is the organization, the short form is TRIPS. So TRIPS is the organization which is keeping a watch on international property rights at the international forum. So they are setting guidelines for all member nations, all member countries, and they have to abide by the guidelines of TRIPS. Every member who is a part of World Trade Organization, they must comply with the guidelines of TRIPS also. If a member is not complying or adopting the guidelines of TRIPS agreement, then a suit may be filed against them under the office of WTO, and there is a settlement mechanism also which will settle the disputes related to intellectual property rights at the international forum. The conflict may exist between respecting and implementing current intellectual property system and other human rights. So there might be a conflict between the intellectual property rights of two countries, or there might be a conflict between the IPR of a country and the human rights of another. So different types of issues might crop up. That is why an international forum like TRIPS is required to resolve these issues. In 2001, the United Nations Committee on Economic, Social and Cultural Rights issued a document which is called Human Rights and Intellectual Property. Now, what is this document saying? This document is saying that intellectual property tends to be governed by economic goals when it should be primarily viewed as a social product in order to serve human well-being. In intellectual property system, they must respect and conform to the human right laws. So, according to the committee, whenever the system fails to do this, then they enter the violation of human rights, which might be a violation related to food, which might be a violation related to health, to cultural participation, or scientific benefit. So, in totality, we could summarize that intellectual property guidelines are required because whatever idea is being taken up in the form of an innovation, in the form of a concept, it has to make some contribution to the society also. So that is why it has to be seen that whatever ideas and concepts they are coming up, they should not violate with the social and cultural issues of that. And this was the reason that TRIPS had formulated a guideline which has to be somehow adopted and followed by all the member nations. It was in 2004 that the WIPO adopted the Geneva Declaration on the Future of the World Intellectual Property Organization, which says that focus should be on the needs of developing countries. So what should be done? Developed countries advanced countries, they should help the less advanced countries or backward countries in strengthening their IPR laws at international forums. When we were doing a lot of research related to intellectual property rights, it also came into our observation that the contribution of women is very less in intellectual property rights. So there is a gender gap in intellectual property. And there was a survey in 2020, according to the WIPO survey, which says that 16.5% of patent holders are women. So the number is very less, and this number is indicating the number of international fora. It is not related to any country or nation. The disparity is perhaps because of the factors like systematic bias, which is there in the social systems, sexism, discrimination within the intellectual property space, and underrepresentation within STEM. That is why we must have seen lot of conferences and seminars which are strengthening the term STEM. So STEM basically stands for sciences, technology, engineering, and management. So these are four branches of discipline which are being promoted at national as well as international forum, so that women contribution increases in the future and we have more patents, copyrights, trademarks related to these four disciplines, which usually encompasses all other remaining disciplines. Talking about the global comparison of international property laws, it is very necessary to understand and know that whatever ideas which are coming in the form of IPR laws, usually they are creation of the mind and they do not result into an immediate product or a service, and they might take some time in converting that idea into a model or a prototype or into the form of a formula or services later on. So as long as that idea stays with the owner, with the creator, it has to be protected so that nobody else comes up with the same idea and gets the credit of it. So IP laws are significant all across the world and in the form of different legal traditions, economic priorities, and also upon the level of development. The first type of IP laws which we are talking about is the patent laws. As I mentioned previously also, that United States has the strongest patent system and they have an office by the name of United States Patent and Trademark Office, which is granting patents for inventions that are new and which are not common. And they're also useful in the long run to the industry as well as to the society. The normal term for patent is 20 years from the filing date. The method is first to file system, meaning the first person to file a patent application generally have the right to the patent. This is the basic idea about United Nations law on patent. Similarly, if we talk about European Union, which has a patent office by the name of European Patent Office, which can be validated in multiple countries of European Union. Their parameters are same as that of United States, but they are more expensive due to translation and validation requirements are different in different states. Since there are a lot of nations which are covered under European Union, so the translation and validation requirements make it a little more expensive. The next important form of IPR is copyright laws. And the four countries which are leading in copyright laws are United States again, European Union, China, and Africa. So they have strong, robust system for copyright laws. Now, this copyright laws, the life which is or the time which is given to the author or the founder is 70 years, and it has a strong enforcement mechanism and is a member of international treaties like Berne Convention. There are a lot of conventions and treaties which have been signed after the formulation of IPR laws at international level. So US is also a part of international treaty like Berne Convention. The second contribution of leading the copyright laws is goes to European Union, which has an inclusive provision of linking tags and uploading filters. So they have also harmonized their copyright laws like United States, and again it is also valid for a period of 70 years. The third leading country in case of copyright laws is China. It was weak in their enforcement laws in the past, but now they have made lot of improvements and they have improvised their existing regulatory framework, and they also adopted the Berne Convention for their copyright protection. And here the copyright lasts for 50 years. The Chinese governments had made efforts to strengthen IP enforcement, particularly in response to international pressure. The fourth country which is leading in copyright laws is Africa, and many nations have influenced by colonial history with legal frameworks which is inherited from European countries. So the same has been adopted by Africa also, and it is African Regional Intellectual Property Organization and African Intellectual Property Organization (OAPI), which works together to strengthen the IP laws in the African continent. The third major form is trademark laws. Again, the major contributor to trademark law is United States and European Union. The United States, it has a well-developed trademark system and it is registered with the Office of USPTO, and it is granted to distinctive marks to identify the source of goods or services. As long as the mark remains in use and periodic renewals are also done. It is followed by European Union. Again, a single registration is done for all the countries which are covered under European Union. The third leading country for trademark is Japan. It has a very strong trademark system with protection granted for distinctive marks which are used in connection with goods or services. It also recognizes non-traditional trademarks such as sound and color marks. The fourth country which is leading for trademark laws is Brazil, which has Brazilian industrial property law, which is similar to that of United States and European Union. And they have also faced a lot of challenges in combating counterfeiting, which was prevalent in their country. The fourth category, which is popular, is trade secrets. Again, the United Nations leads the formulation of trade secret laws, and a lot of legal recourse is available if there is a misappropriation with trade secret laws. Followed by European Union, which has a trade secret directive in 2016, which harmonizes the protection of trade secret across member states. So this has led to more consistent and effective protection across Europe, which is followed by China, which has an anti-unfair competition law, which is there to protect the secret laws of a particular innovator or a creator. And India is at fourth number in case of trade secret laws, which is protection which is offered through contractual agreements, and it is also covered under common law principles. So, this approach makes enforcement less predictable compared to jurisdiction within specific trade secret legislation. The next is international treaties and agreements. The World Trade Organization agreement has set minimal standards for IP protection in all member countries. And how are these laws being governed? They are being governed by TRIPS agreement, that is WTO's part. Then we have Berne Convention, and then we have Paris Convention. So all countries which are framing IP laws, so in order to match with the international platforms and international guidelines, both these conventions are kept into consideration when they formulate laws for intellectual property rights. There are lots of challenges before IPR. First of all, a harmonization is required. There should not be a conflict of interest between two countries which collaborate together for the development of a new idea or a concept. So it is also indirectly related to national sovereignty. So that is why Berne and Paris Convention came into picture. so that countries they tailor their laws to meet the local needs and priorities, because this can lead to disparities between developed and developing countries. So, if there is a collaboration of research between a developed and undeveloped countries, because of disparity in the laws, there might be conflicts in future. So, in order to avoid those conflicts, WITO came into picture and TRIPS was formulated, and it was also said that human rights at international forum should be kept into picture. The second challenge which is created is by the digital age. Because of digitization, there are a lot of piracy issues, there are a lot of counterfeitings, there is a use of trademark in domain names and social media. So again, the IPR laws have to be strengthened from time to time, and maybe we have to formulate new acts to combat the challenges by digitization. The third is the enforcement, which is a challenge. Since we might be having conflicts in different countries also. So, in order to address the issues when there is a conflict between two countries, an international forum was required, which is somehow managed by TRIPS now, and they try to enforce the decisions taken by TRIPS. The fourth challenge which is there is balancing interest. There's a continuous debate over balancing the interest of IP right holders with public interest, particularly in areas like medicine, education, and cultural expression. So, developing countries often push for more flexible IP regimes to address their concern. Since they're already advanced in their innovation, they are more concerned about the balancing interest, which might not be addressed by lesser developed countries at the international forum. We know that IPR laws are evolving day by day, and India also patent law was revised in 2005, Design Act was made. Then we have IT regulations also, which are somehow uh, required for intellectual property rights. So, to keep a balance between the economic, the social, and the legal landscape at the international level is a complex process, and it is not so easy. A significant harmonization may be only done through treaties, through negotiations, agreements, and discussions. Since this is a intellectual property is contributing in the landscape of research, which is influencing every innovation, and somehow it is connected to the dissemination of knowledge. So that is why it is necessary for the researchers, for the academicians, everybody who's related to industry, that they understand the sensitivity of IPR. So IPR is not only about protecting your idea of your own mind, but it is also about your social contribution to the society in the longer run when that idea gets converted into a product or a commodity or a service. So that is why WIPO, that is World Intellectual Property Organization, is trying to protect these rights for all nations irrespective of their nature and existence. If we are going into a collaboration and the two contributors or authors they belong to two different countries, this has to be kept in mind that first of all that which type of collaboration they are going for. They are working for a patent, they are working for a copyright, they are working for a trade design, and then they have to understand the laws related to their particular country, and then they have to come on a common consensus that which type of disclosures should be made and which country should be selected for getting the idea patented or copyrighted, because two countries might be having disparities in their laws. So the actual controversy arises when the authors belong to two different countries. Collaborative research, as I already mentioned, when researchers they take national differences into account when planning for a global collaboration. For example, researchers in US or Japan are collaborating with researchers in European Union that they must agree to restrict public disclosure or publication before filing a patent. In US, it is a common practice that public funded universities they retain patent ownership. However, in Europe, there are different options. So, an ideal collaboration provides that everyone involved with the maximum ownership of patent rights. Several entities specialize in organizing international research collaborations. So the assistance of those agencies or experts can also be taken into cognizance if we are going for a collaborative research between different countries where the IPR laws are not at the same level or are not at the same platform. Now, IP laws they affect research also. They have research implications, and the first is incentivizing innovation and research. The patent as an incentive. We know that the patent is usually given for a period of 20 years, and in a period of this 20 years, the R&D department has to ensure that the patent is converted into a product. But in the case of a pharmaceutical industry, they are crucial for incentivizing the development of new drugs, which involves high cost. So, IP laws, they are just not for protecting the ideas, they are also related to the contribution to the society in the form of economic benefit or in the form of eradicating any social issues or problems which are prevalent in the society. Academic research funding. Patent and other forms of IP can be a significant source of revenue for universities and research institutions. By licensing patent or forming spin-off companies, academic institutions they can generate funds to reinvest in further research. If a university is giving financial support to their innovators, to their researchers, the same fund which is coming through the commercialization of the idea can be used for more research and more collaborations in future. It also puts a restriction on knowledge sharing. One of the major challenges of IP laws is the restriction on access to research output. It can hinder further research and it can slow the pace of scientific progress, especially in the fields of biotechnology, foundational patent, and broad areas of research. It also affects copyright and academic publishing. So, whenever we go for writing research papers, manuscripts, it has to be uh, uh, backed by a copyright so that your own idea or contribution in the form of a new research is not copied by somebody else. It also has an impact on collaboration and open science. It can complicate collaborative research, especially when multiple institutions are involved. There might be issues of patent rights, sharing of royalties, licensing agreement, which can become more contentious and serious in nature. So, clear agreements and IP management strategies are essential to navigate these challenges. In case of open science movement, it can accelerate discovery and it can increase the transparency and reproducibility of research. It also raises concern about how to protect and monetize research outcomes. So it is a key challenge for researchers and policymakers that when they go for collaboration or they are working in an open science space, the, uh, the issues and conflicts are minimized by working out clearly from the very beginning. It also has ethical and social implications. All innovations related to IPR, they are somehow related to public health, and in some cases, it might be related to medicines also. So, it is addressing global health challenges also. So, researchers working in this field must navigate the ethical implications of their work, and there is a balance which is required for innovation with social responsibility, especially for life saving. The other contribution of the problem is that cultural and genetic resources, which involve traditional knowledge or genetic resources, often raise issues of IP and equity. Patents on plant variety. So, whenever people are working on plant varieties or they are working on pharmaceuticals which are derived from traditional knowledge, then it can go into biopioneers. So this has led to the development of a framework which is known as Nagoya Protocol, which seeks to ensure that benefits arising from the use of genetic resources are shared fairly. And the next is because of emerging technologies, especially artificial intelligence is posing new threats for IP laws, and the new type of algorithm and data set they are at the forefront of current debates. So these issues have significant implications for research in artificial intelligence, where the rapid pace of innovation is outstripping the ability of existing IP laws. Gene editing and biotechnology, again, there are chances of having dispute when we are working on patents which are related to editing and biotechnology. A dissimilar type of challenge exists in developing countries. Uh, in developing countries, the laws are very strict, they're very stringent, and people are not able to complete those requirements and they do not go for the filing of IPR. They found it very difficult and complicated. So, countries which are not so developed, they should try to ease out the method of IPR. If people want to go for patents, they both want to go for copyrights, the process should be made easy and simpler so that people apply for these process and they get their ideas protected. Policy constraints. Again, policymakers they face the challenge of balancing the protection of IP with the need to promote research and public access to knowledge. So IP laws do not unduly restrict research, but they provide sufficient incentive for innovation. So it is necessary that compulsory licensing should be adopted by countries so that ideas remain protected and they also come into the knowledge of the government where it is existed in the form of documents. Again, harmonization at a global platform is not easy, but it is required in the longer run. To summarize, we can say that IP laws they have a profound impact on research and how research is being conducted and how the results are being disseminated. These laws are essential for encouraging innovation and protecting the rights of creators. The protection of IP within the need for open, collaborative, and accessible research is a key task for researchers, institutions, and policymakers. Countries which have strong intellectual property laws generally offer robust protection and enforcement mechanisms, and these countries typically have well established legal frameworks. So, here are a look at some of the countries which are regarded as having the best IP laws. So these countries they are known for contributing the best IP laws. I'm not going into the details. You can get this material available on any internet platform. The major contribution is coming from United States, which has a proper system and which is very robust and strong. The second to lead in the list is Germany. Again, has a very responsible IP administration. There are no flaws in their intellectual property rights. The third country is Japan, which has a very robust patent office. The fourth is United Kingdom, which has by the name of UK IPO, which is responsible for administering IP rights, which is followed by South Korea, which has a Korean Intellectual Property Office, which manages all issues related to intellectual property rights, is followed by Switzerland, and the next is Singapore Line, which has developed a robust IP system which supports its position as a global hub for business and innovation. And the last is Canada. So I've selected 8 countries which have a very good IP laws. So if you're coming in interaction for any collaborative research related to these 8 countries, you have to do a comprehensive and a detailed study before entering into an agreement with the author or the founder of these countries. The IP systems are designed to support innovation, protect the right of the creators, and also to foster economic growth. If we talk about IPR laws in India, it refers to the specific type of intangible assets which have been created owing to the application of one's mental faculty. The requirement for obtaining registration for intellectual property may vary depending upon the type. So, IPR are classified in a universal manner across the globe. In India, the different forms are copyright, trademark, patent, geographical indicators, designs, semiconductors, plant varieties, integrated circuit layouts. The first act, which is very well known and is being adopted these days, is the Copyright Act, which was made in 1957, which is for the protection or the expression of idea. rather than the idea itself. In what way the idea is being put up, that is protected. It is in the form of a music, in the form of an artwork, in the form of a design, in the form of a documentary or a film or a literary work. So these are the areas which are covered in copyright in India. And this was for the period of 60 years. The second prominent is Trademark Act, which is there to protect the uh, services of one person from those of others. It may be related to packaging or combination of colors. The third Patent Act, which is popular in India, is Patent Act 1970. It has been revised in 2005, and there are new guidelines to meet the requirements of the new digitization system and the role of AI. So all new act will keep coming up in India also to meet the requirements. The fourth, which is Design Act, which was formulated in the year 2000, which is talking about the feature of the shape of the product, the configuration, the pattern, or the composition of lines or colors which are used. So it is basically related to the design of the product. The next is geographical indicators. For example, there might be a example of Darjeeling tea, which belongs to Darjeeling. Then we have in the form of fabrics from Lucknow, which is known for chicken work. We have Banarsi silk, Bangalore silk. So all these cities which are producing or which have manufacturing a special type of product which is not available in any part of the country, they go under geographical indicators. And this law has been active since 1999, and the protection is given for a period of 10 years from the date. The next, which was uh, drafted to meet the requirement, was in 2001, which is related to the Plant Variety Act to recognize the rights of Indian farmers and to provide protection to the plant varieties. The next, again, it was made in 2000, that is semiconductor integrated layouts protect have transistors and circuitry elements which are protected under this layout. So you will see that there are a lot of acts which are being made up. Even Information Technology Act, which was formulated in 2005, is also covered under IPR. So a lot of comprehensive laws are covered under IPR. It is not restricted to any one act. So when it comes to the part of nations, there are a lot of laws which are being formulated. And when we come into interaction or in an issue with the other country, a lot of homework has to be done, and then only we can understand the existence of IPR. But if you are in research or you are in academics, you should understand the seriousness of IPR laws to avoid any conflicts and issues in future. That's all from my side.
Uh, Thank you, ma'am. Now the question answer session, ma'am. There is a question. If you permit me,
Yes, yes,
may I ask question? Uh,
yes.
the question is visible. Whether the question is visible, ma'am?
How can India's advancement in intellectual property contribute
Yes.
to its comparative global standing? See, if I don't know how much you could interpret from the session I took, but Indian IPR laws are already strengthening day by day, and a lot of new acts are being made to meet the requirements. It's not that India is not at par with global or international standards, but when if we
Yes.
come into a contact with any particular issue, maybe related to patent, maybe related to trademark, so it can be addressed accordingly. I hope I have given the answer.
Okay. One more question is there. Uh,
To
Ayush
what extent does
Sinha.
central see IPR itself cannot make a contribution to the economy directly. IPR is simply protecting the ideas of the innovators. So until and unless those ideas are getting converted into products or services, it cannot contribute anything to the society. IPR laws can play a role only by easing out the process of protecting the ideas, and so that people come up with new ideas, and maybe like startup policies which we have these days, so that people enter into business and entrepreneurship. So supporting policies are also required so that people convert their ideas into products and services. In that way only IPR can make a contribution to the economy. These laws alone cannot make any contribution directly to the society.
Okay, ma'am. So
Any other question?
we are and we are ending the session. It is I think it is you have completed from your side, ma'am. You are done
Yes.
with your side. Okay, ma'am. So I would like to extend my sincere thanks to Professor Dr. Asma Farooq for his insightful session on the topic global comparison of IP laws implication on research. His expertise has greatly deepened our understanding of the importance of the intellectual property in academia. Thank you, ma'am, for your valuable contribution. Thank you, the attendees, for your active participation. Thank you, ma'am, and thank you, attendees.
Thank you, Ashraf. It is a very wide topic, and I hope I have given some